Hello and welcome to Bulletin 47 of the New South Wales Wills Probate and Administration Service. Number of interesting cases in this bulletin. The first is one where an application was made to have the appointed executor removed and an administrator appointed. There was antipathy between the appointed executor, who was the widow of the testator, and the testator's children of an earlier relationship. But more significantly maybe was the fact that the executor had been convicted of criminal offences and may or may not have been receiving a custodial sentence. As happens in all these cases where an application to remove an executor is made, the court considers what is in the best interests of the proper and efficient administration of the estate. There was some suggestion that if there was a custodial sentence, then the grant could be revoked, but otherwise it should stay in place. This is the grant of probate in favour of the widow. And in the end, the court considered that it was in the best interests of the estate's administration, effectively, to have her removed. Her guilty finding in relation to the criminal charges were not of themselves determinative of her ability to act, but here they were, combined with the other issues, no doubt, they were determinative. The next question, or next case rather, to consider was the estate of Dolan, and there was a distribution on intestacy issue. What the will provided was that there was 40% to a biological child of the testator, and then 10% to each of the 6 stepchildren of the testator. One of those stepchildren murdered the testator, and the question, and therefore forfeited his 10%. The question was, what happened to that 10%? And there are a range of options, I suppose, but in the end, the court considered that 10% had to go on an intestacy. A partial intestacy had arisen, and it finished up going to the estate, in effect, of a deceased brother. That is really the essence of it. I did think, however, that there are some jurisdictions, I believe, where it may have gone pro rata amongst the other beneficiaries. That will depend on the specific legislation in other jurisdictions. Here, of course, we're talking about New South Wales, and that was the outcome. The final case referred to is a family provision case, which was a little unusual in some ways because it was a de facto spouse application. She'd been the de facto spouse of the deceased for 23 years, and she was 75 years of age. She didn't have significant resources, I think about $550,000 in assets or capital. She was left a 2-year right of residence in a Hornsby unit and a $20,000 legacy. One of the features that the judge highlighted in the case was that it had always been made very clear to the de facto spouse that she shouldn't be looking to him and his estate, which was in excess of about $3 million, for any maintenance and support. And in fact, the executor perpetual trustees had brought to the attention of the court the relationship between the deceased and his de facto was unconventional, being one that was without any financial or domestic dependence. That in itself was not considered to be determinative, but the issue was that the strong view that there was never an expectation as far as, there should never have been an expectation so far as the applicant was concerned that she would receive anything. That was one thing. The other thing that I thought was a little unusual but worth noting was that Justice Hallen in that case pointed out that the legal obligations imposed by a marriage do not necessarily apply to a de facto relationship. Thought that was an interesting and significant observation by His Honour. In the end, the award in favour of the applicant was 14% of the net proceeds of sale of this Hornsby unit in which she'd been granted a right of residence for 2 years, and that the balance was to be lent to her on a secured interest-free loan to enable her to purchase suitable accommodation. In the course of coming to that conclusion and view, the judge pointed out that the normal or accepted position of a widow of a long marriage, and here 23 years de facto relationship is pretty much mirroring that, was entitled to security of accommodation and income. And I think, although His Honour mentioned that the de facto relationship and a marriage may not be the same, in effect that's what she received by way of provision. And that's it. Thank you.